All right, welcome to the Credit and Collection News podcast. We are here today talking with Don Maurice, who focuses his practice primarily on representing consumer and commercial financial services companies. Most everybody in the industry knows Don. He's been around for a long time. And Don is the expert on New York, and the reason that we have him here is New York is trying to decide whether they want to do business or not in the financial services industry. So it's always going to be interesting with their new legislation, what's happening, and we're lucky enough to have Don here because he is an expert. Particularly in New York, he's definitely litigated in the financial services industry, both in the state and the federal courts. And it ranges everything from truth in lending, ECOA, fair debt collections, TCPA, FCRA, and every other letter that you want to put together with what's going on. He's also the outside counsel to the Receivable Management Association and serves as the chair of the New York City Bar Association's Consumer Affairs Committee. So that's a lot of information about who we're talking with today. And Don, I'm going to turn this over to you because they don't want to hear details. What they want to hear is what's going on in New York and, what do we need to do about it and how do we proceed?
Well, Steve, thanks. Thanks for having me again. It's always great to speak to your group, a very knowledgeable group of people, and this is an area of concern, and I'll get into more particulars why. But first, I want to start with that. This is not legal advice. This is education, and I'll be talking in hypotheticals. If you need legal advice, you've got to talk to an attorney of your own choosing about your specific circumstances. And while I've tried to have everything up to date for our discussion today, it is up to date only through today's date, which is December 5, 2024. With that aside, I could tell you that New York City has decided that they want to put into place some amendments to their existing rules, which have been around for decades. Those rules cover the collection of consumer debt from consumers who reside in the city of New York. The rules have no private right of action. The amendments they propose do not propose a private right of action, but we've seen plenty of lawsuits that have been premised on a violation of the New York City rules and use that as a springboard for an FDCPA claim. And that's really where the concern comes in on the litigation standpoint. And of course, compliant debt collectors want to be compliant with the law, even if there isn't a private right of action. Some of the significant things that New York is doing, again, the way to look at New York City rules is this is anti-Reg F. That's the best way to say it. They didn't like Reg F. The consumer advocates have a lot of influence within New York City. It's New York City Department of Consumer and Worker Protection is the agency that is responsible for these rules. And they began the process over 2 years ago. I participated in the comment sessions of those, and we had at least 2 comment periods. I testified on behalf of RMAI members. I've interacted with the New York City Department of Consumer and Worker Protection's General Counsel, Assistant General Counsel, in my capacity, both as the chair of the New York City Bar's Consumer Affairs Committee and as outside counsel to the RMAI. So I've had a lot of involvement with what's going on here. One of the big things that we need to be mindful of, Steve, is that unlike the FDCPA, New York City does not place a time limit on verification requests. Troubling most is that now verification can be orally requested. Unlike Reg F, which has a 7 and 7 rule, New York City has a hard cap on communications, 3 and 7 days, and I'll describe the differences in more detail between the New York City call cap and the Reg F call cap and why New York City is far different. and that you must obtain written consent for e-communications. And those are pretty big changes. Why should we care? Well, we should care because New York City is larger than 38 states. There is nearly 8.5 million people residing within the 5 boroughs. And the New York State Department of Financial Services has its own debt collection rules and has tried over the past few years to amend those rules without success. But my money is on the bet that New York State is now going to likely adopt regulations which align more with what's happening in New York City. Then we will have 17.5 million people covered by this, by similar rule. Again, that's still out there. We'll have to see what the New York Department of Financial Services does. But from what I'm hearing from both sides, that is from advocates and from industry, is that we're likely to see something. And then if New York City goes through with everything that is proposed here, other states and other cities, like the District of Columbia, which has been active in the past few years, are likely to follow. So that means that we have to be concerned about New York City. So some of the other things that are changes here, and what I'm talking about in these rules are just conduct related. I'm not talking about licensing because New York City does license debt collectors. These are conduct related provisions. And some of it's going to include monthly log requirements. There's changes to that, additional mandated corporate policies that you'll have to have in place. There are changes to the definition of key terms. I'll talk about a few. The deletion of the bona fide error defense, the proposed rules will delete that. Communications restrictions, which I mentioned validation requirements. A few years ago, we saw New York City put out a rule on language preference in debt collections. We see the importation of foreign language preference requirements into the amended rules. Expanded itemization of debt, which I think for some is going to be troublesome, particularly those who are dealing with debt that is a deficiency after a repossession. We have some time bar debt requirements that are different than New York State, different than Reg F. And they've included some restrictions on collection of medical debt as well as credit reporting. So there's a lot of areas to cover, Steve, and they haven't left anything out. So it's a really significant overhaul that New York City has proposed. It's been in the works for over 2 years. We just got the release at the right before the beginning of fall, so late August, early September. We were supposed to have an effective date of December 1, and that didn't happen, fortunately, because the industry responded with this is a lot to do in a few months, and they did not. DCWP did not voluntarily move that date, although we requested them to, and so ACA International filed a lawsuit against the city of New York. And that lawsuit has constitutional basis for it, mostly dealing with the call caps I discussed. But in response to that lawsuit, the DCWP has pushed back the effective date to April 1, 2025. So I'll talk about the lawsuit a little more, but the good news is we're now dealing with April 1, 2025. Why did DCWP do this? I mean, what's going on? Is there a real problem in New York City? Is debt collection harassment at the forefront of the concerns of the city of New York? After all, the city has a lot of things going on. Why do this? And particularly, why do this hard cap of 3 and 7? What happened in New York City? We took a look at the stats, Steve. We looked at the complaint portal from the CFPB, and we found that in the 5 boroughs, there were, I think, let's see, maybe 30, 40 complaints about excessive call frequency in 2023. 40 complaints. And there were a total of complaints in New York City in debt collection of 48,953 in that year. But that's also against creditors, credit reporting agencies too. It's not just debt collectors. Yet, with these like let's say 50 complaints dealing with excessive call frequency, they say, well, we've got to dial this back to only 3 in 7 days. So there's really no support for that. There's no support for the call cap that I discussed, the 3 and 7. So the significant changes in definition, Steve, deal first with the definition of debt. And it does now follow the FDCPA definition. So you're talking about consumer credit. This differs from New York State. New York State covers only consumer credit transactions, which are not all consumer debt, but New York City covers all types of consumer debt. So we have that broad expanse. The rule that exists today covers original creditors in the conduct provisions. The amended rule that they released earlier in the fall did not. And Steve, I'll tell you, we had a meeting at the city bar with the with the DCWP general counsel and his staff, and I don't think they realized that. So they did not realize that they cut out original creditors because they used the FDCPA's definition. And so just the other day, we saw a proposal from the DCWP to amend the definition of covered persons to recapture creditors in the amended rule, which is odd, frankly. If you were working on this rule for over 2 years and you wanted to include creditors and you didn't listen to the comments, because I know that one trade association commended the DCWP for excluding creditors both in their written comments and in their oral testimony. If you would have listened to that, you would have known that you were excluding creditors. The rule, though, does have other exclusions in it that exist today. It excludes state and federal. It also excludes public utilities, which is really odd. So there are excluded classes that exist today: the public utilities, the state, and certain others that are similar to the FDCPA exclusions. But today it covers creditors, and if the DCWP has its way with its amendment, which the comment period on that will end December 12th, it will again include creditors. The other change in the definition, though, is what is an original creditor. When we think about original creditor in the context of the FDCPA and Reg F, we think about the creditor who last owned the debt at the time of default or at the time of charge-off. And this is because consumer credit can have a long life. You could, as I think I did, I started my first consumer credit account in 1981 with a Sears card. Well, Sears hasn't issued credit for decades. And though that portfolio was sold off, as many merchants sold off their portfolios to banks and non-bank lenders, but that credit still exists. So my original creditor under New York, though, would be if my Sears credit card went into collection in New York City, my original creditor under their definition is Sears Roebuck and Company, not Citibank, who I last made my payment to.
Where it originally sits, or where it sits now. You're right. Yeah, I get that.
It's Sears Roebuck, and I think the real problem with this definition is when you're dealing with automobile paper, indirect automobile paper. So a lot of our members, a lot of our industry colleagues are in that space. You have retail installment sale contracts that are provided to the dealers. If you look closely at those contracts, the original creditor is the automobile dealer. So but it's assigned immediately at sale through that paper to a third-party lender.
Right.
Under this rule, let's say I sold a car, Don's Auto Sales. I'm on Staten Island. I sell a car. I assign my paper immediately to PNC Bank. If I were to go to collect that debt in New York City, the original creditor is identified as Don's Auto Sales. So even though I've never made a payment to Don's Auto Sales after I close that transaction, and purchase my car, that's who I identify it as. And I think that's very confusing to consumers. But there's a lot of things confusing in this rule that are going to hurt consumers. So let's talk about communication, since I touched on it earlier in the hard cap. Communications are defined in different ways. We have what's called attempted communication within the rule, and it's really any act to initiate a communication or other contact about a debt. So when you read the New York City rules, unlike Reg F breaks out telephone calls from electronic communications, from
Right.
letters, not the New York City rule. It's all in one. It is a communication, can mean a letter. It can mean in person in court, because after all, this rule does cover attorneys who regularly collect consumer debt. It can mean an email. It can mean a text. It can mean a phone call. So when we begin with counting communications, when we begin with restrictions on communications, we have to think broadly, because it's with any person through any medium. And a limited content message, as they define it, and very similar to Reg F, is an attempted communication, which isn't too much of a change from existing law. But we do cover limited content messages, and of course, New York City, having to be anti-Reg F, has its own type of definition for that. It has to include certain things within the limited content message. I won't go through each of them. They're in the rule, but you have to understand that it is different than Reg F's limited content message required uh, uh, information. Notably, is that New York requires the name of the natural person whom the consumer can contact to reply to the debt collector, and a callback telephone number that is answered by a natural person. So, Steve, I ask you this: when was the last time you called a business or a state or federal agency and that call was answered by a natural person?
1980. When did you get that Sears card? Uh,
81.
yeah, okay, yeah, that's about when it was. Yeah, because I think that's the last time somebody actually answered their phone. Uh,
Yeah. Now we have call processing where calls come in. They may go to a virtual assistant or a
right.
similar type of platform. If you want to speak to Don Maurice, hit one. If you want to, that's not being answered by a natural person.
Right.
Is not being answered by a natural person. And if your person is calling back after hours, if your debtor is calling back after hours, and if that goes to voicemail, that's not being answered by a natural person, is it? I don't know. I don't know what New York City is going to say about that, but I think that's just ridiculous, frankly. Um, there's a reason why we have this call technology. It's to process calls in the most effective way. And it's not about helping consumers in the most effective way to reach the right person. It's just about making people's lives in our industry miserable. That's really what this is about. Another thing that we have here with communications, Steve, is what I think another example of the DCWP just not paying attention to the comments or the testimony. They have a convenient time presumption to contact the consumer, right? And you've seen that in the FDCPA.
Right, right, right.
Well, here it's after 8 a.m. and before 9 p.m. Sounds fair. But then it says Eastern Standard Time.
Okay.
Now, I think that Eastern Standard Time covers winter and fall, and we switch to Eastern Daylight Time in spring and summer. So half of the year, you're going to be contacting your convenient contact times are times different than what is actually between 8 a.m. and before 9 p.m. In other words, if you're contacting someone in spring, right, or summer, we spring ahead.
Right,
So
right.
8 a.m. today in the winter, the fall we're in, we're not winter yet, though it feels like it here in the New York area. 8 a.m. today is 9 a.m. on July 4. But it says Eastern Standard Time, so I guess I have to dial back regardless of the actual time, which is just bizarre. It's the only way to put it.
Yeah,
Bizarre.
that would, yeah, it just seems like something that, yeah, again, you would just put, 8 a.m. to 9 p.m., but that would seem too logical for
For them, yeah.
yeah,
8
in-line.
a.m. or 9 p.m. Right. You just put
Right.
that there. And it should be what? At the location of the consumer. Why is that? Because how many people use cell phones today? Last time I checked, most of the world, at least most of the United States, let me put it that way, most people are using cell phones as their primary device. And they may be vacationing in another locale, which is in a different time zone. So you may be a New York resident sitting here in your home. I like to pick on Staten Island because that's closest to New Jersey, and that's where I live now. But my family is from Staten Island and Brooklyn. You may be either in Staten Island or Brooklyn. I don't care. One of the five boroughs. And you want to take a vacation and you head out to where you are in California.
Right.
Well, that's a 3 hour difference, but it's not location specific. It is Eastern Standard Time, Steve. So I could call you, according to this, I could call you at 5:01 in the morning if you are in California, happen to be in California.
Right.
That may be helpful in some ways. I think to the industry, it doesn't help. It's not helpful to consumers, right? Because it makes it clear to the industry, hey, I got to do it at these times in Eastern time because that's where all New York City sits. But consumers are not, stationary. They're mobile and they move around. But that's another
Right.
thing
And
that
again,
just
if you're dealing with the older debt, your consumer is not, they might have you might have gotten your Sears card in New York, but you could have easily moved to Jersey or
mm,
decided, you know what, I'm going to live part-time in California, I'm going to live part-time in Hawaii, whatever the case may be. So your timing is kind of irrelevant. I mean, during, you could just say during 8 to 9 p.m. of your location. But again, that's
yeah.
difficult
Yeah,
to.
well, yeah, but we're in the same location in New Jersey and New York, right?
Right,
And
right, right,
if you've moved out of New York City and you're now a California resident, these rules would not cover you. That's the
right.
good news for the industry. Also, I think someone asked a question when I was speaking at your conference about this. What about if I'm based as a collector in New York City? I don't think, and I'm collecting from someone in California, I don't think the DCWP sees this as collector regulation, that it has to be a New York City consumer. So that's a question some of your viewers may have, is whether it covers me if I'm a New York City collecting out of New York City into to a resident of another place. So if you're in New York City collecting to someone up in Poughkeepsie, it wouldn't cover it. But if you're in Poughkeepsie collecting to someone in New York City, it would. Another thing that's really odd about this is a lot of restrictions about electronic communications, right? I mentioned, I think earlier, how to get written consent. There is also a means by which a consumer can forbid communication mediums. The consumer can request that the debt collector not use a certain medium to communicate with the consumer. And this request does not have to be in writing at all. And I think, Steve, this is going to cause a real predicament for some sophisticated consumers that get a hold of this. First of all, you had to really understand debt collection and how to make life miserable to write something like this, because here's what it could mean. Essentially, in New York City, you can only communicate by telephone or by letter, right, without written consent. But a consumer could, if you call the consumer and the consumer tells you in that phone call, I don't want you to communicate with me by telephone, and I don't want you to send me a letter. You're done unless you get written consent. And you may have a very hard time getting written consent if you can't send a letter to get the written consent. So it pretty much could shut down your non-legal communications attempts in New York. So I want to get to the real, I think the tough stuff that is going to trouble some people. And it's really a good, the basis for what ACA suit is about. It prohibits communications with excessive frequency, or it would prohibit if it becomes law in New York City. And they define that excessive frequency as meaning more than 3 communications within a 7-day period, or after the consumer has responded to a communication within the 7-day period. So essentially, it is a hard stop after a letter and 2 phone calls within 7 days. You cannot call again or send another letter within that, or like, we'll have to be very careful here. Or the
Right.
consumer cannot receive a letter within that 7-day period after you've made that 1 letter and 2 phone calls within that 7-day period. That is not what Reg F says. Reg F is 7 and 7, presumption of compliance. It does not say in Reg F that you have violated the FDCPA if you exceed the 7. It's just you've lost the presumption. New York says you're violating the law. You have engaged in an abusive, deceptive, and deceitful manner by sending, or be careful, receiving, I guess, that 4th communication in that 7-day period. And that's really where the problem lies, I think, constitutionally, between New York City's call cap and the FDCPA, Reg F. Federal government does not say you cannot call after 7 days. They just say you lose the presumption of compliance. New York City says, at least in their current proposal, if you are a debt collector, you are 3 and 7. However, if you're the government, you could do 707. You could do it all you want. If you're a public utility, you could do all you want. That's a content-based restriction, that if I am making a debt collection communication and I am a debt collector, I am restrained from speech. Even if it's not harassing, even if it's not deceptive, and the Bureau has identified that not all debt collection calls are unwanted. Consumers may want to hear from you. Consumers may want to know that there is an offer that you're willing to make right away if we can get it done, this week. There is a repo agent who may have made those 3 communications already and just found out on day, let's say day 6 of this 7-day period, day 6, that you need this car to get to your dialysis treatment, and they don't want to repo it, and they want to call you up and let you know that. Can't call the consumer. So what ACA is arguing, and rightfully so, is that this is a content-based communication. There is a recent Supreme Court decision, American Political Action Committee versus Barr, where this type of restriction in the TCPA, there was a very similar restriction in TCPA, but it exempted federal government from making debt collection. Well, debt collection calls could be made by the federal government using the ATDS. And they struck it down based on that, saying it was content-based, meaning that only covered debt collectors, covered persons, but the federal government couldn't. If it's harmful for a debt collector to do it, it's just as harmful for the government to do it, or in the case of New York City, a public utility. And actually, of all people to draw a distinction as being unlawful, that distinction as being unlawful was Justice Sotomayor, no friend of our industry, who said in her concurring opinion, she doesn't see the difference between a government debt collection call and a private debt collection call. And frankly, Steve, neither do I. If the city of New York is trying to collect a debt from you, to for whatever reason it is, and if it's covered by this, then certainly that harm is just as great. A public utility, Steve, like
Right.
Con Ed, same problem, but they're exempted. So I think this is where New York City is going to have a tough problem with this, and I don't think their re-inclusion of creditors, their proposed re-inclusion of creditors within this act is going to solve that problem for them, because of course they still have these exemptions for public utilities and government. And so there are a few exemptions to these caps that I want people to be aware of. If the communication that you're making is initiated by or was made at the request of the consumer, it wouldn't be covered. If it responds to a communication from the consumer, quote unquote, in the same email thread or live chat, it's okay. If you didn't connect to the dialed number, I don't know what that means exactly. If it means that you got a busy signal, or it was just this call cannot be connected type of return that you got from the phone service, I guess that would be it. But I mean, I don't know if I'm going to go
Well,
as
yeah,
far as
you'd be down to negative. Yeah, right. Yeah.
uh, returned mail or a bounced email would not count towards this if it was required by law. GLBA disclosures, for example, New York State disclosures, which is just as applicable, by the way, to New York City residents. And then if it was litigation related, so there's a bonus for our debt collection attorneys there. Another big difference here between New York City proposed amendment and existing Reg F. Reg F is per account. So in other words, my 7 and 7 applies if I have 5 accounts for a creditor that I'm collecting from an individual. I get to call 7 times on each of those accounts. Under New York City, it's per creditor. So if I have 8 accounts,
Yeah. Yeah.
I can't call
Ouch.
you. I'm really done because I could only do 3 times. And I guess I have to throw them all together, which is confusing as anything, because how could I do that in a letter? How would I do that in a phone call without stumbling over myself or creating some confusion? That would be very risky. But New York City is per creditor on their cap. Um, it's a big change, I think, too, Steve, because the current rule sets up a presumption, right? New York City's current rule, by the way, a lot of people don't realize this. And here's something for some people that is going to be a surprise. And I'm going to read it word for word. Debt collectors shall assume that more than twice during a 7-day calendar day period is excessively frequent. So it's only 2 and 7
Wow.
today, but it's only a presumption, right? And assume, right, that more than twice during a 7 calendar day period is excessively frequent. So we're going from, like Reg F, which is current law, presumption, to no, under the new one, it would be you're done at 3, and any more calls would be a violation. And remember, I had all these logs and monitoring that you have to do if you're collecting debt in New York City. And they're going to look for these to see how many times you made these communications. It's not just phone calls, it's letters, it's emails, it's in person. For debt collection attorneys, it's a problem, Steve, because you're in court, right? And the consumer is there. That counts. You see what I mean?
Yeah.
So
Yeah.
unless it's litigation related or court ordered or required by law, or at the other exemptions I mentioned, debt collection attorneys going to court when the consumer's there, they're going to have to count that too, right? So it could be a problem. So let's move on to another form of communication that everyone likes to talk about, and that's always on the forefront of where we are today, because so many younger people communicate this way. It's e-communications, electronic communications.
Exactly.
You have 2 options for electronic communications. Revocable written consent. I mentioned you got to obtain written consent, right? or the consumer used the e-communication platform to communicate with the debt collector about a debt within the past 60 days, and the consumer has not since opted out. So if the consumer is emailing you within the past 60 days about a debt and they have not opted out, that's good. Or you get revocable consent. And this is going to be hard for a lot of people. Um, and it has to be given directly to the debt collector, Steve. And this is unlike what we've seen elsewhere. I know I was on a presentation not long ago where someone asked, well, if I give it, if the contract has that the creditor can contact you, or that we can contact you, or affiliates can contact you, is that gonna fly, right? This is pre-charge off, pre-default. I really don't think I can read the rule that way, Steve. I think you're gonna have a tough time reading the rule that way. I think it has to be given specifically to that debt collector. At least that's the impression that I've gotten from the DCWP, is that if it is given to the creditor, it's not going to work for you. If it was given to a prior debt collector, it's not going to work for you. The language is directly to the debt collector to use such e-communication platform. So it's got to be email, it's got to be text, or maybe all electronic communications, you could say, to communicate about the specific debt too, Steve. So it can't be, you could communicate, I'm hereby giving you written consent to communicate with me about all debts. I don't know. I don't know, because New York City language says about the specific debt.
Perfect.
So,
Yeah.
so it's causing, again, I really believe the consumer advocates were very much involved in writing these rules. Very much.
They just didn't want to. They basically nobody wants to collect on any more New York debt. Yeah, I'm getting that.
You can send an email to obtain written consent, but only after receiving oral consent. Just send the email. And you cannot collect until that written consent is received. So you can send them your form for the written consent by email if they've orally agreed to that, but you
So that
can't.
you have to, or so let's get this straight. You have to orally agree. So you got a consumer that normally, if they work obviously under e-commerce because that's how it's set up, because that's, basically anybody younger than us, pretty much that's how they do business. So they really don't use their phones anymore. So, but somehow or another, you've got to get that oral permission to then go to the email, which is really the reason that yeah, I get it. It's not
If it,
possible.
if the consumer reaches out to you, right, and let's say you've got on your website, or you sent a letter and you said, um, you could reach us by email, you could reach us by uh, text or whatever, uh, and they text you.
That's not oral permission.
Yeah.
Yeah, this is difficult. Yeah, I get it.
The only good part of this is you can obtain written consent by federal or New York e-sign laws. So the USA e-sign Act would allow you to do it, and the New York State um, uh, comparable act would allow you to do it. Of course, you got some hoops to jump through to do that, but you could set that up, and I think some of our colleagues have already done that, Steve. So, but the problem is getting this written consent. And again, it can be oral done. If you're on a phone call and you say, can I send you an email? Then we could do communications by email or text, but you got to get me back that written consent. That would
Right.
work. If they don't give it back to you, you're done. Unless, of course, they're emailing you about a specific debt, right? That was the thing, within 60 days. That was the other allowance. So if they're reaching out to you, and that's the thing I mentioned in the letter, maybe you'll drop something in the letter that you can reach us by email or text here, right?
Yeah,
Because
yeah.
then you're getting some from the consumer. Hey, I'm texting you about this debt.
Right.
right? This specific debt. Well, there you go. There you go. So, it's something to think about. Obviously, it's not something to do lightly, okay? But it's something to think about. You must have opt-out in all communications, all e-communications. And that just be by replying stop, I guess, would be an example they use. Has to be clear and conspicuous. Um, so, we've gotten through communications. We've gotten through, I think, the heart of some of the more difficult stuff on communications. But let's not leave out credit furnishing because New York is changing its rules on that. You can only furnish after you've sent a New York validation notice that clearly and conspicuously states, quote, that the information about the debt will be reported to a consumer reporting agency. You must wait 14 days from sending that to verify that the notice was not returned. So
Oh,
there you go. There you go. We don't want to leave that out, right? Do we?
no, of course not, because yeah, that yeah, I'm not sending any solicitations to anybody that lives in the city of New York anymore, obviously.
Yeah,
Uh,
well, we got more. You send your first letter, your validation letter, right?
right.
Um, New York already has, New York City and New York State, by the way, also have certain requirements that you must include in certain validation notices. But New York City continues pretty much the same, that except that this whole thing, quote unquote, Steve, telephone number that is answered by a natural person during all times when a debt collector conducts business. Okay, well, now we know it's conducting business, answered at all times when the debt collector conducts business. So, again, can we go to that phone tree? I don't, I'm not
Yeah,
about to come up, opine about that.
yeah, because in most agencies that are doing business, they don't just collect, obviously, on people in New York. So they're doing business, I would say, at least the 12 hours, for along those lines during.
Must be answered, yeah, it must be answered by a natural person and the name of the natural person to contact. So I don't know if they're necessarily the same, right? That the
Right.
name of the person to contact, name of the natural person to contact must be on that letter, and the phone answered by a natural person. It sounds like they could be different. There also has to be, of course, what would an amended rule be without further disclosures? And they added a whole 3 paragraphs of additional disclosures here. One of which is just one of the things I mentioned at the beginning. There is no time limit to dispute the debt and collection. You can let collectors know you dispute the debt using any of the ways they contact you, including by phone. So they want to make that clear. And then you've got this whole period. I mean, I think we don't have a lot of time. There's a lot going on to this rule, but I'll just tell you this. You've got to verify debt now if this rule goes through in New York within 45 days. And if you don't, following a dispute, if you don't get that verification done, then you got to send a notice of unverified debt. And you may not be able to, you as the debt collector may not be able to continue to collection if you cannot verify that debt. Your disclosure, by the way, that you have to send to everyone also would inform the debt collector if any about medical debt changes, even though it may not be medical debt. So more paper, more disclosures. Can't put it on the reverse side, but you got to have a disclosure on the front side. Must be clear and conspicuous reference to the reverse side. You've got itemization that you've got to put on this. It's pretty much lines up with Reg F, but not fully. So their itemization reference date is for revolving and open-end credit accounts, the charge-off date of the debt, or on closed-end counts, either the date of last payment or the charge-off of the debt. Now that's where we get into the problem with repos too, because the date of last payment is not the deficiency balance at
Right,
all,
right.
right? So you're running a Mercedes Benz, what is it? One of those like SUVs they have that are like $150,000. You know what I'm talking about? And you
Right.
made one payment on it, you got a $150,000 debt, and then it's repoed and they sell it for $125,000, right? So you only got a $25,000 debt. According to this, the itemization date is either the amount due at the last payment, which was $150,000. I charge it off. I go repo it after I charge it off. See what I
Right.
mean? So I'm
Right.
giving them the wrong amount, but that's how they want to help consumers. Um, there's another wacky thing in here that we don't know exactly what they mean or what they're talking about. I don't think they do. Um, it must include if the amount changed during the pre-charge off period, it must add a line for the amount of debt as of the date of last written notification. I have no idea where they're going with
Uh,
this.
I, what happened to clear and conspicuous? Yeah, that's yeah. Okay, I get it.
So, the amount did change between the pre-charge off period. If you're running an open-end credit, an open-end plan, right? A credit
Right.
card, it's constantly changing. What are you talking about? Um, as of the last written notification sent to the consumer on or before the institution of debt collection procedures. I mean, look, I've got my own thoughts about what we have to include there, but I would just direct people to realize that Reg F does not align with what New York City is calling for itemization. And of course, if there's other fees or costs, you'd have to include those too. Again, with disputes and verification, a dispute requires verification under New York City and ostensibly, under the FDCPA and Reg F as well. But remember, New York City can come as any time, can be written or oral, and they never define dispute. So we don't know exactly what they mean. You can also request verification too. So disputes and verification are not necessarily the same. But again, it could be oral or written. It could be at any time. Uh, you must be aware, again, that you've got 45 days to respond. There are certain things you have to include within that response. Um, they can request more than once. I want people to be aware of this. New York City will tell you no, but I think they can the way it's written. Whether or not your requirement to whether or not you're subject to that 45-day period, I think is questionable, but they can request a second. And of course, because they treat disputes and verification differently, you can have both of those, one verification request and one dispute request, arguably, that are different and are both subject to that 45-day period. Steve, have I confused you yet?
I'm getting there. Yeah. Like I said, if I'm a creditor, I'm just shutting it down. I'm moving on. I got, even though New York is larger than 38 states, I think I'm going to the other 38 states.
The If you get a dispute as to the amount of the debt, then you got to go with this enhanced verification. That's where we get into signed contracts, applications, copy of documents provided to debtor while account was active, would include a charge-off statement or most recent monthly statement recording a purchase, payment, or balance transfer if it was a credit card or revolving credit account. Um, the the final account statement that would apply to this enhanced verification would have to have been one mailed to the consumer. So it had to have been mailed to the consumer by the creditor. Wow, Steve, I know we got a lot going on here. I just want to talk about judgments quickly.
Okay.
Uh, so, under FDCPA, under Reg F, under pretty much every state or even DC, the judgment can be used to verify a debt. Doesn't matter how you obtain it. It could be default, could be on merits, not under these proposed rules. A default judgment, if it is not going to satisfy these, you're going to have to provide the docs to do verification, the enhanced verification. If it's on the merits, meaning it was contested and you got a summary judgment or a trial, it's a rebuttable presumption of compliance only. So that's a big difference here. And let me see what else I have. We have the unverified debt that is that must be sent to the debtor if you don't get it done within the 45 days. Time bar debt, Steve, we got a whole another set of disclosures here. Okay, so we're just if it's time barred and you're collecting it, you got to give a whole nother set of disclosures. And there's redelivery of these disclosures, by the way. It's not just once, Steve. This goes on and on and on, these disclosures, every time you continue to collect the debt. And you must disclose the time barred disclosures during oral communications before making your collection attempt.
Wow.
I'm not going to go through the rest, other than there's a lot of record retention requirements that are just very new, very different. Um, we hope the ACA lawsuit is going to achieve some results that are positive for us. I don't know if it's going to achieve all of the things that I've pointed out are problematic here. I think that the biggest one is going to be the call cap 3 and 7, but otherwise, you really need to take a close look if you're collecting in New York City or from a New York City resident, because this is not your Reg F. This is very different. It's very comprehensive. And like I said, I have seen plenty of plaintiffs' attorneys use a violation of New York City's rules to piggyback onto an FDCPA claim. So there you have it in about 45 minutes.
Well, yeah, if yeah, like I said, this is a game changer because and I know it got delayed and now we're looking at April 1st of 2025, but yeah, this is something that obviously the ACA is aware, the the RMAI. I mean, this is like I said, it's a complete game changer, and that's one of the reasons I wanted to have you kind of at least delve a little bit into it because this is something that realistically it can change the whole concept of lending in New York City, and which again moves to New York State. California and New York seem to, they adopt these crazy these rules. And
Absolutely. Absolutely. Steve, it's not just New York, California. We could read off the other states too. I mean, Colorado comes to mind, Oregon, Washington. These have always been the hot states, Illinois, Minnesota, right? Massachusetts,
exactly,
Connecticut, right?
exactly.
DC. Don't forget DC.
No, and that's yeah, I get it, and I know well they're already. I mean, obviously the elections have consequences and stuff, and this is um, granted this was started before the they knew the results, but this is what's going to lead to other these other states that lean a different way than the red states that obviously they're going to try to adopt these same type of rules that and again I'm not really sure how you do business to comply with all this stuff. I mean, you just basically instead of going that, the next obvious step is you litigate instead of trying to
Yeah.
collect on it. Because
Yeah.
if you make it so impossible to collect on the debt, and that's honestly a lot of this is close to impossible. Um, that's what I think, and it's the repercussions. That's what happens. If you make it impossible to collect, the debt's still owed, and if the debt's still owed and you can't use a debt collector to do it, then the next step is litigation.
I think that bringing creditors back in the proposed now into the amended rule is going to be helpful to the industry, because if this were to equally apply to creditors, obviously it's going to make it just difficult for them. Steve, you want to do lending in New York, you can't even in-house collect without doing all the things I described here. It's nonsense. It truly is nonsense. It is difficult. The data, they have no data to support these restrictions. Nothing. Zero. They didn't present a single thing, and they don't have any. It's
Right.
not about it is people ask, well, why do they do this? They do it because they just dislike creditors. They just dislike creditors. They just
Yeah.
do not. There's so many pieces of consumer harm that I noted here. How it creates consumer confusion, giving you misinformation. As we're directed to give you, we'd be directed to misinform the consumer to about who the creditor is, about what's due. So anyway,
Yeah, no, and I know and when back at the beginning when we started and we started talking about this, well, what led to this, and I believe you said somewhere in the area of 50 complaints. Um, and you look at the numbers, it's just not. I mean, when they say, this has to be significant, this has to be natural, and I mean, you're just not. That doesn't make it makes zero sense. It really does, because the number of complaints coming in as opposed to, the reality of it just they don't balance each other out, and the harm that's caused. And again, they don't think about that till afterwards. But that's really what it's basically doing is you're basically setting, and the courts aren't, if every suddenly you had to take all this stuff and litigate it, the New York courts would be overwhelmed. You just couldn't do it. There's no way to do that route. And it's just, like I said, you throw your hands in the air and say, okay, well,
well, there's another thing to consider too, and I'll just mention it briefly because look, I'm familiar with New York. I've lived in this area all my life. Um, there are other routes to consumer lending that do not involve banks or non-banks that are freely available here.
okay, well,
They will prosper.
yeah,
They will
yeah,
put, as lenders to those who are financially disadvantaged find it more and more difficult to lend, and after something like this, just essentially pull out. The others will prosper, and they're not going to get a license. They're not
right.
going to. They're not worried about call caps, but
Yeah,
that's
that's yeah.
how
Well,
people
they
will
are
have to
they're
borrow.
yeah, yeah, they're more interested in the, hey, yeah, if you don't pay us back by Friday, well, we're gonna send Guido out and Guido will take care of it. So
Or
that
whomever. Yeah, exactly. And that's a real thing here. It is not fantasy. This is not something I'm making up. This is real, and it's been around for over 100 years, and it's not going anywhere. And as avenues and choices for consumers decline, they step in, and they do. So this is the route we're taking, Steve. But we'll see what happens with ACA. I mean, we the whole industry is behind. I know that RMAI has been lending support, NCBA has been lending support. Now with the creditors coming in, I think we'll maybe get some more support. Maybe they'll file their own suit. I don't know, but there's a lot going on here, Steve. So we'll keep you up to date on it. That's for sure.
well, definitely. Well, I know, like I said, it's one of the reasons I love having you come speak at our conferences, is because you're a plethora of information, and like I said, most people will walk away from this shaking their heads, going, "Oh, well, I just don't see how you do business this way." And but it's actually, I mean, it's the ultimate bureaucracy. This is not, nobody voted for this.
No,
This is not what they voted for. This is not what they're trying to do. This is just bureaucracy out of control. And it's
he
crazy to think.
I want to throw something out there, one thing for you to walk away with on this too. Really, okay? If they're successful with pulling creditors back in, this applies to the very small businesses in New York trying to collect the debt. Dry cleaner, right? Someone who doing housekeeping services, it applies to them equally. So
Right.
this is small business harmful. It's so many different harms to this. We'll see where it goes, but it's look, there's always solutions. We work on these solutions. We've been working with our clients now since the rules were announced. Um, it's difficult. It's not impossible to do. It's filled with risks, but it's doable. It's very, very difficult though to do.
Yeah, it's like I said, it's just, and the people that watch this and the people that read the newsletter and the people that go, these are the people that want to comply. They want to follow the rules. I mean, they want to do business the correct way. And that's an issue, because I mean, if you make it so difficult, like you're talking about, and this is really, it's what it's becoming. It's becoming difficult to do business. You're pushing the people that want to do it the right way out of the business, which leaves, I mean, people still need to borrow, and they're still going to need to do this, and then people are still going to need to collect.
Mhm.
But if the people that follow the rules won't do it, then the people that won't follow the rules will, and that's a whole different, hey, those are the ones that, create the bureaucracies in the first place, because they're the ones that just kind of, hey, if they're calling at 3 in the morning, they're calling at 3 in the morning. They're knocking at your door saying, "This is what I'm going to do." That's what they're going to do, and that's like I said, that introduces a whole different, you know those aren't that's not the industry. That's not what the industry wants. That's not what the industry does. The industry tries to follow everything and do it in a professional way. So there we have it. So Don, thank you. This was very enlightening. Like I said, we have our next big conference coming up in April. And gee, that's look at that. April 1st is when this is all supposed to go to fruition. Hopefully it gets pushed back again, because that's, again, with some sort of adaptions that we can make it reasonable. But
I think we'll see some changes between now and April 1. So, Steve, we'll be prepared to talk about those amongst other things.
that sounds perfect. Don, thank you so much
Thank
for
you,
taking
buddy.
the time and explaining. Like I said, we don't want to cut off New York City from all the credit, because let's face it, that's a large chunk of business that everybody wants to do business in. We all want to do business in New York City because we want to work with the consumers there. And I'm not just not sure what the bureaucrats are thinking, but never really sure what the bureaucrats are thinking.
You
All
got it,
right, with
pal.
with that, like I said, we're gonna wrap it up. If you have questions, contact us. I can also give you Don's direct contact information if you give us a call. You don't even have to follow all the rules to give us a call. You can call us anytime, or email, or send me a text, and we'll get it taken care of. With that, thank you, Don, and look forward to hopefully getting some good news out of New York City next.
We'll try.
All
Thank you,
right,
buddy.
there you go. Have a great day.
You too.